Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense here on YouTube. Last couple of weeks I've talked about what I would call First Amendment auditors, and I've said pretty much that they're idiots. But there are some people who are real First Amendment auditors, and we'll talk about one of those next. Amaya Cahoon went on a band trip with her high school down to Florida during spring break in March of 2020, and she contracted COVID-19. When she came back to Wisconsin, she posted two things on social media about having contracted COVID-19. Apparently, this generated some phone calls to her high school from concerned fellow students and their parents, and also some calls to the public health department. This wound its way out to the sheriff, who sent Sergeant Clump. No, I'm not making that up. He sent Sergeant Clump out to the door to knock on the door and say, "You need to take that down or somebody's going to jail." Well, what does the First Amendment say? Well, first of all, it says that we have the absolute right to free speech. That Congress shall make no law abridging the freedom of speech. Why is that there? Because that's exactly what the king did in England back in the 1700s. He made laws that made it unlawful for people to speak their mind. So preserving our freedom of speech is a pretty important goal, I think. And the idea that you could send the sheriff out to throw either a teenager or her parents in jail simply because they posted something about something that happened to them that was truthful. Nevertheless, that's what the sheriff did, and of course, Sergeant Clump went out and did exactly that because that's what he was told to do. You know, when I was in the Army, one of the things that they told us is you don't have to follow an unlawful order. In this case, Sergeant Clump would have done well to have evaluated whether or not that order was lawful. At any rate, he went out, made the threat, and although they didn't think it was right, they removed the social media posts. Then they did a little bit of First Amendment auditing. They contacted an attorney and they sued for a declaratory judgment that the young lady's First Amendment rights were violated. Now think about this in contrast with all of these First Amendment auditors who do this stuff for likes on YouTube. These folks were not trying to get likes on YouTube. They were trying to validate a principle that the government can't tell you what to say and think. And as a result, they took it to the district court in the state of Wisconsin. The federal district court issued an order. Let's look at that now. In the United States District Court, Eastern District of Wisconsin, Amaya Cahoon plaintiff versus Joseph R. Conrath and Cameron Clump, defendants. Order granting plaintiff declaratory judgment. The SARS-CoV-2 virus and COVID-19 have had a tremendous impact on American society, but as this case makes clear, that impact has its limits and more specifically does not extend to overriding the protections of the First Amendment. On April 16, 2020, teenage plaintiff Amaya Cahoon, by and through her parents, filed a complaint alleging defendants Sheriff Joseph Conrath and Patrol Sergeant Cameron Clump violated Amaya's First and 14th Amendment rights when Sergeant Clump, at Sheriff Conrath's direction, demanded that Amaya remove a social media post. The court goes on to note that the parties agree that the facts are not disputed. Indeed, the entirety of Sergeant Clump's encounter with Amaya and her parents is captured in a dash cam video. That video, along with other record evidence, establishes that defendants violated Amaya's free speech rights by demanding that she take down her social media posts or face criminal citation or arrest. Accordingly, Amaya is entitled to summary judgment on her declaratory judgment claim, and for the same reason, defendant's summary judgment motion must be denied. The court will deny the injunctive relief request, I'll explain that later, and her counsel conceded that a declaratory judgment would be a sufficient remedy. Just so I don't get any haters in here wondering why it is that we're not talking about what was in the posts, this is an example of one of the things that was in the post. This is a picture of Amaya wearing a face mask, an oxygen mask, that shows her receiving oxygen therapy for COVID-19. This is not an image that would provoke someone to violence or anything like that. It's not an untruthful image. It wasn't a staged image. It was simply an image that she posted on her Instagram account, I believe it was, to let people know that she was a little bit under the weather, but she was going to beat the thing. Now, it's always interesting to me to take a look at what the government does when it does things, and in this case, the sheriff opposed this declaratory judgment, even though it wasn't asking for any money damages. And it said that the sheriff said that she did not have standing to raise these claims because the threat of arrest was made to her parents, as if the parents do not control the actions of a 16-year-old child. So that's what the entire controversy was about. It was about posts like this. And let's see what the court said when it got to the conclusion of this case. The court says the First Amendment is not a game setting for the government to toggle off and on. It applies in times of tranquility and in times of strife. While defendants in this case may have believed their actions serve the greater good, that belief cannot insulate them. Demanding a 16-year-old remove protected speech from her Instagram account is a First Amendment violation. Declaratory judgment is hereby granted. Accordingly, it is hereby ordered the plaintiff's motion for summary judgment under Federal Rule of Civil Procedure 56 is granted. It's not a game setting. What a wonderful turn of phrase that is. The judge here obviously got this absolutely right. Well, that's the order. And I hope that in looking at that, you recognize just how important it is to have real First Amendment auditors. People who are willing to go into court, not into municipal court, but into an actual federal courtroom, and stand up for principles like the First Amendment. The Cahoons and their lawyer are patriots. They are people who stood for a principle. They pushed back against authoritarianism, and they won. That's an important lesson for all of us. If you found this interesting or thought-provoking, I would love it if you would subscribe to the channel if you haven't already done so. And I would also appreciate it if you'd give me a like, because that tells the YouTube algorithm that this is worthwhile content for other people. Thank you so much for watching. And if you have any comments, leave them in the comments down below. Otherwise, I'll catch you on here next time. Thanks.